Judge, I think Mr. Evans is here in my office, and I think what he's looking for are the other just on camera lens, but the kind of the pre-hearing documents, like the waiver and such things that he has to sign with the client.
Oh, there's this document here.
Mm-hmm.
I go over these admonishments on the record.
Okay.
Yeah.
So if you would like a written copy for your client to understand, I don't mind. You can find the courtroom. I can give it to you. But everything that's contained in this document, I go over with your client on the record. So.
And I think for the most part, you already have, Judge. So.
Yes, and a lot of it's duplicitous with the stipulation.
Yep. Gotcha. I don't think I will come get a written copy, but I don't think we need to bog it down and have me do it now. So I'll be in about 2 seconds. I'll be ready to go back on the record.
Okay.
Okay.
Yeah, they told me. Oh, yeah, get that from the prosecutor. So.
I think it's
So
just
you don't need this.
void.
Okay.
All right. No problem.
Have you seen this? Okay. I'm going to go over all those anyways. So I don't require it. Some people do it because of habit. Some people just don't like change. The very first jury trial I ever did was with Lynn Evans. When I was a baby attorney. I was trying to get experience. He let me sit with him.
Okay. Judge, we're set to go. I apologize for the delay.
Not a problem at all. All right, so we're back on the record. So I don't remember if the record caught your answer, so I'm going to ask, Mr. Evans, is your client, is there any reason why your client will not understand the proceedings today?
There's no reason. He will understand, Judge.
Okay, is he fit to proceed?
Yes, he is fit to proceed.
All right. So, Mr. Wood, this is going to take a minute just because of the length of the petition, but I need to go over some things with you. All right. You're here today because the state of Texas has filed a petition alleging that you have engaged in delinquent conduct, which, if committed by an adult, would constitute an offense against the laws of Texas. Specifically, I understand we're not proceeding on paragraph 1, but this is what's alleged. In paragraph 1, they're saying on or about July 3rd, 2018, in Tarrant County, Texas, that you intentionally or knowingly threatened imminent bodily injury to Stephanie Campbell, and you did use or exhibit a deadly weapon during the assault, specifically a firearm. In paragraph 2, it is saying that on or about July 3rd, 2018, in Tarrant County, Texas, that you knowingly discharged a firearm at or in the direction of a habitation occupied by Stephanie Campbell and was reckless as to whether the habitation was occupied. Paragraph 3 is that you engaged in delinquent conduct on or about July 3rd, 2018 in Tarrant County, Texas, when you intentionally or knowingly caused bodily injury to Bridget Cantrell by shooting her with a gun, and that you did use or exhibit a deadly weapon during the commission of the assault, specifically a firearm. In paragraph 4, that on or about July 3rd, 2018 in Tarrant County, Texas, that you intentionally or knowingly caused bodily injury to Pedro Garcia Jr. by shooting him with a gun, and that you did use or exhibit a deadly weapon during the commission of the assault, specifically a firearm. Paragraph 5, that on or about July 3rd, 2018 in Tarrant County, Texas, that you knowingly discharged a firearm at or in the direction of a habitation occupied by Bridget Cantrell and was reckless as to whether the habitation was occupied. Paragraph 6, that on or about July 3rd, 2018 in Tarrant County, Texas, that you knowingly discharged a firearm at or in the direction of a habitation occupied by Pedro Garcia Jr. and was reckless as to whether the habitation was occupied. Paragraph 7, that on or about July 3rd, 2018 in Tarrant County, Texas, that you knowingly discharged a firearm at or in the direction of a habitation occupied by Pedro Garcia Sr. and you're reckless as to whether that habitation was occupied. Paragraph 8, that on or about July 3rd, 2018 in Tarrant County, Texas, that you knowingly discharged a firearm at or in the direction of a habitation occupied by Lauren De La Rosa and was reckless as to whether the habitation was occupied. Paragraph 9, on or about July 3rd, 2018 in Tarrant County, Texas, that you knowingly discharged a firearm at or in the direction of a habitation occupied by Roy Zapata and was reckless as to whether the habitation was occupied. Paragraph 10, that on or about July 3rd, 2018 in Tarrant County, Texas, you knowingly discharged a firearm at or in the direction of a habitation occupied by Julian Cesalem and was reckless as to whether that habitation was occupied. Right. You understand what you're being charged with?
Yes, sir.
All right, state waive opening. Mr. Bumberg? You're on mute, Mr.
All right,
Bumberg.
yep, got it. Stay waves opening, yes, sir.
All right. All right, any exhibits from the state for adjudication?
Yes, Judge. We would, on adjudication, I previously discussed with the defense lawyer and the court, we would ask that the DME manifest be made a part of the court's file.
So Mr. Bumberg, I have the DME manifest filed with the court. I also have the supplement filed with the court. I have the stipulation agreement filed with the court, and I have a trial amendment filed with the court. And those
Yes,
are
sir.
file marked and as part of the record.
Okay.
Um,
As far as exhibits on adjudication, we do not have any exhibits. At the proper time, I would like to be allowed to speak as to the petition, but I'll wait for the proper.
I'm sorry, you came in kind of quiet. You would like to what?
All right, I'd like to speak to the petition and the plea agreement, but at the proper time. I just didn't want to.
Okay.
We did file with the defense attorney's agreement, a trial amendment, made the court aware of that. As you stated earlier, we are waiving paragraph 1 of the petition and proceeding on 2 through 10. And then we are proceeding on the original petition, not the grand jury approval, as part of the plea agreement.
Okay.
And sorry, as to answer your direct question, which was, do we have any exhibits on adjudication? We have no formal exhibits on adjudication, Judge. Except for the stipulation there, which I understand was made a part of the court's file.
Right, that is filed. All right, so Mr. Jackson, so first the court has noted that it is accepting the trial amendment that is signed by attorneys for both parties, which amends paragraph 3 and 4 of the petition. All right, so Mr. Wood, there's a couple things I want to go over with you. All right, so now I'm looking at the stipulation of evidence, judicial confession, and disposition agreement. Do you recognize this document? The stamp up here is new, but otherwise, do you recognize this document?
Yes, sir.
Okay. So in here, it's alleging that, and I was going to ask you, on this last page, there's certain signature lines. And do you recognize that signature there?
Yes, sir.
Okay, is that your signature?
Yes, sir.
Okay. So this is a little bit different than the petition. So we're skipping paragraph 1, but it's saying in paragraph 2 that this document says that you knowingly discharge a firearm at a habitation occupied by Stephanie Campbell. were reckless, and it's a third-degree felony. Paragraph 3 is saying that that you recklessly caused bodily injury to Bridget Cantrell by shooting her with a gun. Paragraph 4 is that you recklessly caused bodily injury to Pedro Garcia Jr. by shooting him with a gun. Paragraph 5, it is saying that you knowingly discharged a firearm at the direction of a habitation occupied by Bridget Cantrell and was reckless about whether somebody was in there or not. Paragraph 6, 7, 8, 9, and 10 follow what I had previously read out in the record. Did you go over this with your attorney?
Yes, sir.
Okay. So then what I'm going to ask you is, do you know what the word stipulation means?
Yes, sir.
Okay, not a problem. Most kids don't. So a stipulation is when two people agree to something and they will openly say, we agree. So what we have here, if you look at this, is my robe. We can say that it's black, right?
Yes, sir.
Would you agree that it's black?
Yes, sir.
So we can stipulate that it's a black robe, right? And there's no disagreement about it. But if I was to say, if you look at Mr. Shipley in this background, if I said the background for his Zoom session was pink, could you agree that it was pink?
No, sir.
Right? So we could not stipulate as to that fact. Do you understand what a stipulation is?
Yes, sir.
It's a fancy word for an agreement. It's just a very formal way of saying an agreement, okay? So this whole document is called a stipulation. So then my question to you is, do you agree to everything that is listed in this document?
Yes, sir.
Okay, so you stipulate that this is true. Is that correct?
Yes, Your Honor.
Okay, so everything in here, is it true in all the paragraphs 2, 3, 4, 5, 6, 7, 8, 9, and 10? Are they all, as they're written, true or not true?
True.
Okay. Now, are you saying true because it is true and for no other reason?
Yes, sir.
Okay. Did anybody induce you to say true? Did anybody offer you any kind of promise or reward by saying true?
No, sir.
Did anybody coerce you to say true? That means, did anybody threaten you any kind of harm if you do not say true?
No, sir.
Okay. Are you saying true voluntarily?
Yes, sir.
Okay. What does the word voluntary mean to you?
On my own. Or- Yeah.
I'm sorry, I didn't hear what you said.
On my own.
On your own. Okay. So you signed this on your own. Is that correct?
Yes, sir.
Okay. Now there's some enhancements in here saying that there were deadly weapons being used. Right. So is it true or not true that in the appropriate places that there was a deadly weapon, specifically a firearm, that was used?
True.
It's true. Okay. All right. Stay wave closing.
Stay wave closing.
Respondent wave close.
We'd waive close, Your Honor.
So based on the competent evidence provided in this hearing, the court will make a finding of delinquency. Specifically, the court will find that the allegations in the petition of paragraphs 2, 3, 4, 5, 6, 7, 8, 9, and 10 were established by the evidence. The court will also make an affirmative finding that a deadly weapon was used. And that will conclude the adjudication hearing portion of this matter. Okay, are we ready to proceed to dispo?
State's ready.
Respondent's ready.
Everybody's ready? The court will call cause number 323-108-418-18. This is styled in the matter of Aaron Jackson Wood, a child. The court, having previously adjudicated this child as delinquent for the offenses of deadly conduct and aggravated assault with a deadly weapon, will now proceed to the disposition portion of this matter. State waive opening.
State waive's opening.
Exhibits from the state.
Yes, sir. At this time, we would offer petitioner's exhibit number 1 and 2 being the social history and the victim court report containing restitution information.
All right, this having been pre-submitted to the court reporter and now having handed over to the court. Any objections to petitioners 1 and 2, Mr. Evans?
No objection.
All right, petitioners 1 and 2 admitted. All right, any other exhibits from the state?
No, Your Honor.
Is there an allocution in this matter?
There is not.
Okay. All right, defense, any exhibits?
No exhibits, Your Honor, except in argument, I may refer to some documents that, quite frankly, I believe juvenile probation either has or has access to, but I note that I don't think that they were included or mentioned in the social history. But yeah, if need be, I could provide copies, but I was just going to basically mention them in my argument to the court.
Okay.
And let me refer, I think it'd be simpler if I just told you what I was referring to. This case kind of has a tangled history. My client was on juvenile probation at the time of this offense that you've just found adjudicated him delinquent on. And as a result, partially of these cases, his probation was revoked and he was sent to TJJD. I think you're aware of that from the documents you have. He successfully completed his stay at TJJD. After that, he was sent to a place called Lake Granbury Youth Services and received treatment and services from that place. He was admitted in November of 2018 and discharged in July of 2019. He was also placed on parole by TJJD and has successfully completed that period of parole. The reason I mention this is that I discovered when going over the social history that there were some comments in there about treatment or possible need for treatment that may be addressed by what he went through, what he was provided for at Lake Granbury in 2018-19, and I can provide that document to the court if for some reason probation does not have that document.
Well, I mean, because my thought is there's an agreement here.
Judge, you're right. You're right.
So
It may not be necessary.
Okay. I'm wondering if you're trying to talk your way out of me following this agreement.
No.
Okay.
I just was wanting to make sure that if you had any questions after reading the social history, that they were properly addressed. That's all.
Okay. All right. All right. So otherwise no exhibits or witnesses from the respondent.
No, Your Honor.
Okay. Closings from the state.
Yes, sir. We just asked that the court follow the plea agreement and order restitution as detailed on the stipulation pursuant to the plea agreement, Judge.
All right. Closing from the respondent.
Judge, we also would just urge the court to follow the plea agreement.
How quickly can this restitution be paid?
Judge, if you don't mind, let me mute for 2 seconds and I'll get you an answer to that question.
Sure. Thank you.
Your Honor.
Yes.
This is Officer Shipley. I'm sure you are able to see that there's also a balance from a prior adjudication and disposition where there's still restitution to be paid.
Correct. No, I do see that.
Okay, Judge, I've talked to the family and that can be paid pretty much immediately. My client did have a question and I did not represent him at his revocation. He was given some information that because he was revoked, the restitution from the prior case kind of became moot. So I did have a question about that.
Well, I'm not sure about that because we're only presenting new cases, but I do see in the stipulation that there's an agreement that there would be restitution in the old cause number for $315.62.
And we did agree to that.
Okay.
Sure.
So, and I'm not part of the negotiation process, Mr. Wood, but it may be that the DA was willing to do this if you were to make that may have been an important part to them. I don't know. All I know is it's in the document, right? So what I calculate the total is $1,671.75, right? Is this something that can be paid promptly?
Yes, sir.
Yes, Your Honor.
Okay. Given that there was a care flight trip in here, that seems like most of it was covered by a third party. All right. All right, so the court, having heard the competent evidence provided in this disposition hearing, will find that the child is in need of rehabilitation and the protection of the public and the child requires disposition to be made. Right? The court will honor and follow the stipulation and plea bargain agreement, which is place the child on probation until his 18th birthday, and order restitution of the amount of $1,356.13 in this cause, and the remaining balance of restitution of $315.62 to the victim in cause number 103786, and that is out of this same court. The court will also make a finding under Texas Family Code 54.044 that the child's parents had made a reasonable good faith effort to prevent the child from engaging in delinquent conduct, and that despite the parents' efforts, the child continued to engage in such conduct. And so this court shall waive any requirement of community service that may be imposed on a parent under this section of code. The court is ordering restitution in the total amount of $1,671.75. Mr. Wood, specifically the reason for this disposition is one, it's a plea bargain agreement that both sides agreed. I'm going to let you know up front that based on the petition, it looks really bad, and I'm not sure, like as a judge, I'm not sure why this is being followed, but I don't have all the information. Haven't talked to the witnesses. I don't know the story. I know your attorney and the district attorney came to this agreement. They felt like that's what's best. I'm not a player in the game. I'm just making sure this is legal. So I will honor this agreement, but it gives me great, great concern because the conduct was so dangerous. I will tell you what, if I am ever close to rejecting a plea bargain, this would be it. Aside from the fact, I think the best thing is the fact that you went to TJJD. They did release you on parole. So to a point, they have kind of their seal of approval on you that you've been rehabilitated. I'm not sure what another trip to TJJD would do for you at this point. So I'm letting you know the fact that you made good decisions while you were there is coming back and benefiting you today. You understand? That you did well there. And so that's why you're benefiting from that. Hopefully this is a good life lesson to you to understand that you can make decisions that will come back and hurt you, or make bad decisions that will come back and hurt you, or make good decisions that will come back and benefit you. A lot of times what you see as the play right now is not the long play. You see what I'm saying?
Yes, sir.
Okay, so continue to make good decisions. I'm glad that you are doing well on parole. All right, so specifically the reason for this disposition is the protection of the public and rehabilitation of the child. Finally, Mr. Wood, I'm going to let you know that even if your probation does get revoked, because the state has waived the determinate sentence, this is under an indeterminate sentence, I could send you to TJJD all the way up until your 19th birthday, but you cannot be transferred to adult prison out of this case. Do you understand?
Yes, sir.
Okay, you understand you're 17 years old now, so that if you do commit any offenses against the laws of the state, you'll be facing charges in the adult court, not the juvenile court. Do you understand?
Yes, sir.
Okay. Also, will let you know that because I followed this plea bargaining agreement, you do not have a right to appeal. This will be final. Do you understand that?
Yes, sir.
Okay. And that your case may be eligible for sealing of records. It really kind of depends on how all this plays out. If your previous case cannot be sealed, but these actually may be able to. And then at this point, Mr. Boneberg, I see nothing in the evidence that reflects that the victim or intended victim was under 17 years old. Is that correct?
That is correct.
Okay. All right. So the court will not make an affirmative finding that the victim or intended victim was under 17. Mr. Wood, do you have any questions for me right now?
No, sir.
Okay. So what I need to tell juvenile probation is it is very important to this court that restitution be paid. So if we go by a couple months and there hasn't been restitution paid, please notify the court and we'll proceed with that. So that is an important part of proceeding with this. Yes.
Let me check one thing now that you mention it, because there is one victim on here whose age I need to check.
Well, Mr. Boneberg, so I'm not asking for factual evidence. I'm asking if there's anything in the record already presented that has it. And I don't recall.
No, you're right.
Okay.
Sorry.
I,
Misunderstood.
I see your point, but I think I'm kind of stuck here after rest and close. So,
Yes, sir.
okay. So, Mr. Wood, do you have any questions for me?
No, sir.
All right. Good decisions come from experience. Experience comes from bad decisions. So it looks like you have a lot of experience. Okay. Please take that and start making better decisions like it seems like you have been in the recent past. Okay.
Yes, sir.
All right. Thank you, sir.
Thank you all.
Hello, Ms. Farmer. Yes.
I believe Miss Uzuaki's online
She is.
already. So,
Child's here. The child's parents are not. I'm gonna wait for them, and there's an interpreter on this one as well. I know everyone's here. Ms. Paxton is looking for the room for the appearance and then confirming the interpreter. But I'm going to step down for a second, so I'll turn off my video. But the audio is still on. If you need to talk to me, please holler.
Okay,
Thank you, Judge.
thank you.
Hey.
Hey.
I'm still in this
No
Zoom
worries.
hearing.
Hi, Ms. Paxton.
Hi.
Did we talk to Stephanie?
Oh, no, I didn't.
Oh, okay.
Let me
Um,
talk to Stephanie, sorry.
We can call and find out.
Okay.
Did you get the parents to the room?
Yes, they're in there.
I wonder if somebody shut down the computer. I'll send a bailiff over to check it out. Oh, there she is. Okay.
There she is, okay. You're calling Stephanie? Or
Yes,
someone?
I was talking to her right now. Yes. Yeah, that was unique. I mean, such short probation had me concerned, but he's one of the rare cases you go to TJJD before you get adjudicated.
Absolutely. That was different.
But this also explains why it took so long to resolve the case. All right, so can you let me know, let's say 90. Let's have a quick one. 60 days. Yeah, if it's not paid in 60 days, then let's just go ahead and file a motion to modify.
Okay.
Thank you.
All right. Thank you.
Okay. All right, Ms. Paxton, Stephanie's looking into it right now.
Thank you.
Yes, see if she can. We'll be waiting for the answer. Okay, so Ms. Paxton, I have no doubt that you asked for it, but the court did not get an interpreter lined up.
Okay.
And we need an interpreter for this. So she's trying to see if they can provide one through Zoom, which is actually the nice thing about Zoom. If she can, then we'll proceed. If we cannot, then we have to reschedule. Okay.
Hopefully
All right. Okay, so we cannot get an interpreter. So this is the court's fault. So at this point, I'm getting Stephanie to join us on Zoom. And if I can get dates on when we will be available, and so we can reschedule this. I think what Ms. Hester was saying is that she can't get them to answer the phone. And so we can't, I mean, I would love to schedule something right now, but I'd just like to get like 3 dates in the future from probably Ms. Uzuihe and Ms. Farmer, your schedules. And then with those 3 dates, now I will let you know that I am out next week. So if Ms. Saberi does not want to waive district judge, which is fine, but it can't happen until the week after next. So right. So, I mean, unless we can, you know, if we can shoot for, well, no, Friday is going to be really tough. We can try and do it tomorrow, and we'll keep on trying to call for an interpreter, but there's no guarantee of that quick. Okay, so Ms. Hester, are you? We're still waiting on her. So I asked her to join the Zoom session so that we can try and get dates and she can write them down and have it all in place.
May I say something, Your Honor?
Yes.
Okay, and also to let you know that my client's leader is also okay to have the hearing before Judge Terry.
Okay.
Cora. So she signed a waiver just in case you're not available, depending on what day we get, because we want it as soon as possible.
Right. So what I have the waiver of district judge. My understanding was before she did not wish to waive district judge.
Correct.
At this point, she has a change of heart and she is okay.
She changed her mind.
Okay, good.
Then and
all right.
then, yeah.
Then what we can do is we can go ahead and Ms. Kelleher, you're here. If we can just get 3 dates in the future that fits the schedules of the attorneys, and then we can go ahead and reschedule this with an interpreter. Obviously, I know we can't get a hold of the interpreter right now, but that way we have the dates available so we can ask them when they will be available. I told them I'll be out of town next week. And so Ms. Uzuihe just said that Ms. Saberi will be willing to do this in front of one of the associate judges next week if we can fit that in. So,
is there a preference?
Ms. Uzuihe, do you have a preference? Does she have a preference between the 2 associate judges?
Yeah, well, Judge Terry, rather, Judge Terry.
Okay.
Actually, the mom even sent me a text message, but then I didn't know how to request it from court because, you know, I didn't want it to be like, but the thing is that she signed a waiver saying that, yes, she can go before Judge Terry.
I have the waiver signed here. So does Judge Terry, how about this? Is Ms. Uzuihe, Ms. Farmer, does Monday, Wednesday, Friday fit your schedules next week?
Let me grab my schedule here.
Any day next week should be fine for me, Judge.
Are we okay? So I have a contempt hearing in the morning on Monday, but I can definitely do afternoon on Monday. I can also definitely do afternoon on Tuesday.
Okay.
I have a contested hearing on Monday that's likely going to be moved because it's contested, but other than that, it should be free.
And,
so would Monday, Wednesday, Friday afternoons, is that going to be available for you?
You mean this Friday? I can do this Friday, Your Honor.
Next Friday.
Oh, next Friday. No, I have deposition.
Okay. No, that's fine.
I can do Wednesday. I have doctor's appointment in the afternoon.
So how about next week, Monday, Tuesday, Wednesday afternoons? Are those available?
You mean next week, right?
Next week, correct.
Yes, I can do Monday in the afternoon, and I can do Tuesday in the afternoon.
What about Wednesday afternoon?
You know, Wednesday afternoon, I have a doctor's appointment at 2, but if we can do...
How about Wednesday morning? Or Thursday afternoon?
I can do Thursday afternoon for sure.
Okay, so Monday, Tuesday, Monday, Tuesday, Thursday afternoon works for you?
Yes, Thursday morning, Thursday afternoon is also good.
Ms. Farmer, that works for you?
I think that'll be fine, Your Honor.
Okay. All right, so Ms. Kelleher, if you can see if the interpreter is available Monday, Tuesday, or Thursday afternoons, just the earliest one. So that way we can have a disposition for Ms. Saberi as soon as possible.
Okay.
Okay.
Can you hold 1 second?
Yeah, sure.
Second. Okay, so Monday, Tuesdays, or Thursdays?
No, not Wednesday afternoon. So Monday, Tuesday, or Thursday.
Right. Monday, Tuesday, Thursday afternoon.
Yes, and just
Right,
whatever the
okay.
earliest one the interpreter can do. And then if you let the attorneys know, and then we can go ahead and reschedule for then.
Will do. Our
Okay?
apologies for the inconvenience.
Thank you, Miss Mary.
Thank you.
All right, thanks, everyone. Sorry, Ms.
Okay.
Saberi, but you will see a judge next week, it looks like, okay?
All right.
All right,
Yes,
thank
Your
you.
Honor. Thank you so much, Your Honor. I'll tell how I'll explain it to her too.
I'm sorry about this rescheduling. I apologize.
It's all right. I explained it to her. Thank you, Judge.
All right, have a good day.
Thank you.